It's very rare that M&A transactions take over the national news cycle. I'm thinking perhaps back to the hostile takeover of Nabisco. Not since then has an M&A deal gotten so much coverage as the transaction between Elon Musk and his personal bid to take over Twitter. Today we'll discuss and we'll see what we can learn from the transaction. And I think we have a perfect guest for the conversation. Professor Eric Talley teaches at Columbia Law School. He teaches on M&A law and brings with him a PhD from Stanford in economics. So I think should be able to shed some unique light on the topic. Professor, welcome to Talks on Law.
Hey, it's great to be here, Joel. Thanks for having me.
A pleasure, and I can see that I'm not reaching you in your Columbia Law School offices.
You have indeed reached me in my person cave at home. I am my interest and commitment to the Musk case is so great, Joel, that I am willing to work through a bout of COVID, and that's what I'm dealing with right now. But the M&A deal must go on, as they say, so I'm keeping tabs on it.
Wow. Well, as a former M&A lawyer in a past life, I know the dedication to the deal, and I must say you look great. But if you need to take a break at any point, we'll do that.
Sounds good. Thanks a lot.
Why don't we tee this up with a quick overview? I mentioned how this has really captured national attention, and there's so many reasons why. It's a social media platform that millions use. It's America's most famous entrepreneur and the world's richest man, and just a lot of drama involved as well. But before we get into the weeds, what do you think is exceptional about this transaction?
Well, maybe it's a little easier to list what's not exceptional about this transaction. The non-exceptional part is that this is an uninvited buyer who suddenly met with success, worked out a contract, and then almost immediately changed his mind. Beyond that, everything is pretty much imbued with the personality of Elon Musk. And I think we don't go down any of these roads without understanding kind of the unique position that he seems to occupy, both kind of the national landscape, but also kind of in the landscape of sort of corporate finance and corporate management, stewardship and ownership. You know, you go back in this case, the beginning of January 2022, no one had an inkling that Elon Musk might be interested in buying Twitter. I'm not even sure Elon Musk did. And some point in the early spring, late winter 2022, he decided to muse publicly over Twitter that he was interested in buying the company. And they weren't looking for a buyer. They weren't up for sale. And then they suddenly were sort of confronted with this person, and it wasn't just some rando guy. It was the richest guy in the world, who said, I think I might want to just own the company. And usually when that happens, the person is bluffing. They're pretending they want to own the company. What they really want to do is be on the board of the company and influence things that are going on, so they don't have to pay as much to actually buy the company. With Musk, it was always kind of unclear because, you know, it wasn't clear whether that threat was empty or not. But if you'll recall, in early March and actually going into April, Musk was poised to become a member of the board of Twitter.
At this point, he had announced he had taken a significant ownership in the company, but for many, and I'm curious your thoughts, did you think that was as far as it was going to go?
I think people thought, at least for the moment, that was as far as things were going to go. Anytime you have an activist, and in fact, Mr. Musk would be deemed to be an activist by the time he was offered a seat on the board, there's always a chance that they're going to try to actually finish a takeover of the company. But usually once you've got them on the board, you've made them sign a standstill agreement that says they're not going to try to take over the company for 3 years, and it buys you some breathing room. And in this case, they got up to maybe the 5-yard line. He was about to go on the board, was probably confronted with some of this standstill agreement language, and then backed out, basically having convinced themselves and maybe having been convinced by some of those around him that maybe he should just buy the company. He is someone who could actually make good on a threat to do so. So in a pretty dramatic 180 that happened at the very end of March and early April, he turned himself from someone who was about to join the board to someone who was tweeting things like "love me tender," which was a very, very veiled threat to make a so-called tender offer directly to the shareholders of Twitter to buy their shares.
Maybe this is a good time to kind of lay out the basic steps again for the subset of the audience who might have not have been following it. This kicked off back in early 2022.
Yeah, it was in the first quarter of 2022. It's sort of a slow roil, and then things really got heated end of March and early April, and that's when the poison pill had been put up, when there were negotiations about him being on the board, when he had disclosed that he had already bought about 9% of Twitter, and once you cross the 5% threshold, you have to make that disclosure. So he was outed as a person who potentially was going to try to buy up a bunch of shares of the company on a hostile basis. And this is, if you go back in kind of the annals of history in public company governance, this is not that unusual. This is a very 1980s kind of moment, right? Where there's someone who is, possibly thinking about a takeover. Carl Icahn sort of comes to mind. You're trying to take over a company on a hostile basis. The board's trying to figure out what to do, and they're going to probably try to resist that person for one of two reasons, if not both. One, they kind of know their jobs are done if this person takes over the company. So they might have a reason to sort of try to stay in power. Somewhat less selfishly, though, if this outsider is going to buy the company and the board's going to lose their jobs, they at the very least want to be able to bargain for a really good price for that acquisition. So a lot of times boards will implement these these defensive measures, and the poison pill was the main one here, to essentially signal to the person that's bidding, Elon Musk in this case, that you're just going to have to stop dead in your tracks unless you go through us. You're going to have to bargain with us, because if you don't bargain with us and you go straight to the shareholders, you're going to be forced to eat this poison pill, and it's not going to be pleasant.
I don't want to refer to a poison pill as a roadblock, because it can be prohibitive, but you're describing it serving a dual role. One, it could stop the deal dead in its tracks, or it might just be a way to bump up the purchase price.
Yeah, and the best way to defend a poison pill is to say, look, we're using it for bargaining leverage to decide when and if we want to sell the company. And if we choose to do so on terms that are maximally beneficial to the shareholders, who are essentially going to be shown the door because of this deal. So that's how most people will defend the poison pill. And it effectively, there's different versions of these things, but they effectively have the flavor of, in a kind of an odd, ironic analogy to the storied scorched earth defense made so popular by Russia, right? That the poison pill doesn't directly keep you from buying stock, but it causes what you get once you successfully buy the stock to be almost worthless. So in some cases, it's because you trigger an obligation for the company to just start hemorrhaging money to everyone else but the person that has bought up some minimal stake, 20%, for instance, of the company. In some cases, and this one was this latter case, all the other shareholders, except for the person that's crossed this threshold, suddenly get to turn their one share into 5 or 6 shares apiece. And so suddenly, you get up to 20%. Everyone else converts themselves, 1 to 5 or 1 to 6 conversion, and it pushes you all the way back down to 4% again, and you have to start all over again. At which point they can reload the poison pill, and this game can go on and on and on until the acquirer finally gives up and sits down and bargains with the company.
That's interesting. We asked a prior guest, and maybe you have more data. Do you know of a poison pill ever being fired multiple times in a hostile deal?
No, only once. I think the only one that I'm aware of was about 15 years ago. It was a really, really low threshold. It was a 5% threshold in a case called Selectica versus Versata. And there the acquirer basically said, look, we think that the 5% poison pill isn't enforceable, so we're going to deliberately breach it and then try to litigate in court. And in that case, they did. They busted through the top. The board then re-implemented it again after it diluted them down. That's when they sued. They didn't try to bust through it again, because at that point they had standing to sue. They didn't want to have both standing and potentially really take it in the kneecaps if they lost, which they did.
Fascinating. So, why don't we go a minute or two? I mean, in the grand scheme of things, I guess it's a few days before the poison pill was enacted. You mentioned Elon was offered the board seat and he got cold feet. And some people speculated that it had to do with what you described as a standstill agreement. These were obligations put on him as a board member. What were some of those obligations?
So when you sign up as a board member, particularly if you have come onto the board as an activist, these companies aren't stupid, right? Even Twitter, which has been described as a dumpster fire, was well advised on this, that you need to make sure that there's an understanding that if you're bringing this person inside the war council tent, that they're not basically using all the strategies that you're talking about to lead a palace coup. So typically what will happen when someone comes onto a board from an activist position is that they're going to be required to sign a relatively demanding contract that says, not only can you not make moves to take over this company, you can't work with other people who are thinking of taking over this company. You cannot supply any other people with information. You cannot act in a way that's inconsistent with the ongoing vitality of this company as opposed to its takeover by someone else. So, and that's, usually something that is thought to be a relatively, strict and binding contract. It does tie your hands. And, I think most people sort of feel like Mr. Musk, might have at least at that point in time decided he wanted to make such foundational and wholesale changes to the company that he wouldn't have the votes to do it as a single board member. And therefore he didn't want to tie his hands, and he was going to actually take a move to take over the company as a whole and try, if he could, to defeat that poison pill.
I could see how for someone like him who's running a number of companies with near total control, the idea that, we're going to give you more power, we're going to give you a say, but that means you can't increase your ownership, you can't say bad things about the company. We're going to add these restrictions on you and your life.
Yeah, that's typically the trade-off there, and realize for most people that's totally worth it, right? Because to engineer an actual takeover of the company means you got to buy up the company. You got to buy out all the stockholders, which means you're going to either have to, rifle through your couch cushions yourselves to find that money, or you're going to have to borrow it or find enough friends to do it. The calculus changes a little bit if you're the richest man in the world who has a bunch of friends who, on the basis of a text that says ride or die, I'll just give you a bunch of money. So I think Mr. Musk, in his view, wasn't that far away from being able to just, to do the entire thing, hook, line, and sinker, so long as he could convince the board to remove that poison pill. Because if he couldn't do that, all the money in the world wouldn't keep that poison pill from just getting reloaded, and the shareholders would never, get the chance to even vote on a transaction where the board would be recommending a sale to him.
Well, let's talk about how he overcame it, and I think the short answer is $40-some billion, or a significant premium over the market price. What happened back in April?
Well, so when Mr. Musk finally came forward with an offer, everyone knew he was going to do it by then because he just backed off of the board. He was, only in a thinly veiled way tweeting about this, which is a little bit problematic from a securities law perspective. And at some point he comes out with an offer. Now the offer, one of the things that I think some people know quite well about Elon Musk is that he's got this kind of odd infatuation with various types of magic numbers, including the 420 meme, the 20th of April sort of National Marijuana Day meme. And so he made a bid of 5420 to buy the company. That was not a terrible offer. It did offer a relatively good premium over where Twitter had been trading before he got interested in the company. Now, usually what happens when a board has a poison pill and they get one of those offers is they will treat it as a first offer. They will say, okay, thank you, Mr. Musk, for that first offer. In his offer, for a variety of reasons, possibly because he was super interested in making sure that 420 stayed in his offer. He basically said, "This is my last and final offer. I am not gonna go any higher. You cannot get me to go any higher. I will make it on very, very seller friendly terms, so that it's going to be not there aren't going to be a lot of ways that this deal can go sideways, because that's one of the things that people care about. If they're selling a company and then suddenly, oh, gee, the deal is off after you're 2 or 3 months into the process." So he, in a fairly public way, both through a letter and through tweets, say, "This is a great offer. I've done it in a way that has not only a good price, but doesn't give me a lot of escape hatches. I'm going to waive the type of pre-bid investigation that a lot of people do, called the due diligence process, and I'm just going to give you this offer, kind of on the basis of what I already think I know about the company."
Well, I want to talk about the favorable terms, because this is going to be so relevant in our conversation, particularly his decision on the diligence process. What exactly was what he waived? He decided he was willing to forego any diligence, or he was willing to accept a very restricted diligence?
Yeah, so there are essentially 2 points of time in one of these deals in which you have the opportunity to do investigation of the company, to kick the tires, to look under the hood, to kind of get a sense of what is it that I'm buying. One is before the bid takes place, right? That there's often a process in a so-called friendly or negotiated deal in which the parties are actually going back and forth for quite some time ahead of the transaction, trying to satisfy the buyer as to some of the biggest issues that are associated with the deal. Now, they may not make it to the finish line, right? It's not a perfect world. You don't necessarily learn everything. But a lot of that, if you do it before you try to price the deal, before you try to specify what the deal is going to look like, can be very helpful to the buyer. It's also, it's also a little time consuming and a little bit costly. So he was basically saying, look, I'm not going to drag you through any of that process. I am not going to put you at all in any position where you're having to open up the kimono to people that I'm sending over. You can just negotiate this right now.
You mentioned this time period between signing and closing. Again, M&A lawyers don't need an explanation, but for those who are watching who don't, these are 2 major steps, and they don't necessarily occur simultaneously. Maybe you can walk through like a quick overview. What is signing? Why is signing separate from closing? And what happens between?
Yeah, so in some M&A deals, signing and closing happens on the same day, and you can accomplish them simultaneously. And those are relatively clean deals, but they typically don't involve companies that are publicly traded companies that potentially have regulatory burdens associated with them. So in a case that involves a public company, already an acquisition is going to require a vote of the selling company's shareholders. In order to have that vote, you've got to notice the shareholders. You have to schedule a special shareholder meeting. You may have millions of shareholders scattered all over the place. You have to send them proxy materials so that they can digest what the nature of this transaction is. And then you have to convene the meeting and vote. And that's just with your shareholders. For public companies, they're also relatively large, and therefore it may be that antitrust authorities are going to really care about it. It may be that foreign direct investment authorities, right, sort of national security concerns may come into play, because this is, effectively the marketplace of exchange. It could be that tax authorities or other authorities are going to come into play that need to sign off on this deal after you've actually signed the contracts, but before the payment and the transfer of ownership is actually made.
The period between signing and closing, as you mentioned, could be instant. It could be as far out as a number of months. And during that period, what's going on at the company level and with the acquirer?
Great. So during that period of time, the company is trying to continue doing business, obviously. And not only do they want to, because, maybe this thing falls apart, though this deal, was locked up pretty tightly, but also they're going to be under an obligation. The buyer who's coming in doesn't want to get to a position where the seller has realized, hey, we've now sold the company, so let's just take up golf and forget about running this company in a reasonable way. So there were obligations that Twitter was under to keep running the company. And so best they could, they were going to continue running the company as it was just a going concern waiting for this day of closing to take place. Now, on top of that, there were things that were actually, envisioned to be a little bit more, again, these narrow alleys of additional investigatory rights that Mr. Musk had. The main one is the right to ask for additional information from Twitter in a manner that was supposed to be related to consummating the transaction. Those were the terms that were used in the contract itself. And this would involve things like information about bots and information about what the account numbers look like and information about monetizability of your account members and so forth. And that provision was, is one of a small number of covenants that Twitter had towards Mr. Musk, in addition to just run this company in its ordinary course. But it also gave Twitter a fair amount of discretion to say, look, you're asking for something that might imperil the privacy of our user base. You're asking for something that might be sketchy on a legal grounds for us to give you until you own the company. So we're going to refuse on that. And so the informational rights that Mr. Musk had, they also had limits to them that were essentially based on Twitter's determination that it couldn't give them or couldn't give up certain types of information because of some of these other problems. When Mr. Musk, shortly after signing up this deal, got convinced that he didn't want to go through the deal anymore, those information rights were the key ones that he was effectively using. It's not the only one, right? The sort of running the business and seeking his input in running the business were another constellation of some of those avenues. But there really weren't that many other places where Mr. Musk had rights to do a whole bunch of drilling into this company to find out more information. And once you're in a position where you actually think you might want to run away from the transaction, you'd like to look for any escape hatch that you can find. And there just weren't too many escape hatch handles that he could grab onto. This was one, but it was always going to be a little bit of limited utility.
You mentioned it. There's no spoilers here. Elon attempted to back out. Twitter sued. And then since then, it looks like the deal is back on. However, why don't before we get there, a couple of more basic M&A concepts I want to touch on, since I have a man who teaches the topic. This is a public company. How do you take it private? I'm sure this could be a whole 2-hour lecture, but maybe an overview. You buy a certain amount and then you can force it private. How does it work?
Yeah, so there are a couple different ways you can do it. An old school way is just to try to buy 51% of the company, and then you pretty much have the majority of the shares. You can vote people onto the board and so forth. Because of poison pills, no one actually gets up to 51% anymore. They're going to be stopped dead in their tracks, as was Elon Musk. So he's sitting there at about 9.9%. So the typical way that you'll go about doing it is using one of several different types of statutory schemes in which effectively it'll come down to a shareholder vote. And if the shareholders vote to accept the deal, not only do the shareholders who have voted to accept the deal, but even people who have voted no are effectively forced to give up their shares, in this case, in exchange for $54.20 per share. Now, sometimes you can set the structures up so that it involves a bunch of specialty companies that have been set up just for the purpose of entering into this acquisition. And this acquisition had the flavor of what M&A people call a reverse triangular merger, which we don't even have to get into the details, but it did then sort of require setting up a couple of other shell companies so that when the smoke cleared from the transaction, Twitter actually still existed as a company. It was the thing that survived, but it was owned indirectly by Mr. Musk rather than by Twitter shareholders. So when they vote and the deal closes, they are essentially surrendering their shares. Their shares are forcibly exchanged for a right to receive $54.20 cash each. And Twitter then issues common shares to Mr. Musk as all one foul swoop of what goes on. And that's how they envisioned it here as well. So you don't have to buy up the entire company. In this case, it was only 9.9%. But you did have to convince at least another 40.2% of the shareholders to vote in favor of the transaction. And, when this deal got signed up, given where Twitter's stock had been trading, I think a lot of people thought, that's a pretty good premium. But, the board decided they were going to take that offer from Mr. Musk. It was his offer, and they were going to negotiate with him. And they came out at the end of that weekend with exactly the same price, right? They didn't get any price concessions from him. It stayed exactly that same price. And so, early on in this process, people were thinking, the board is going to get sued by Twitter shareholders because they caved in bargaining. They didn't bargain him up to 56.20 or something like that. And then, shortly after they signed up the deal, not only did Mr. Musk start to get cold feet, but the entire tech sector started to retrench. And it turned out that not only was 54.20 an okay price for Twitter, every day that passed, it was a better and better and better price for Twitter,
because the whole sector was hemorrhaging share value.
Yeah, the entire this was essentially a deflating football, and having locked in a price that was not bad. Maybe they could have weaseled their way to a little bit more. Within days, it looked like a good price, and so weirdly, Twitter's board emerged looking like kind of the Forrest Gump-like geniuses of having locked in this price that now, but by today's standards, if Elon Musk weren't in the picture, I think most people think Twitter would be trading between $20 and $25 a share. So by today's standards, that was a fantastic price. And, the rest of the market's been tanking as well. In fact, you look at these days of carnage in the stock market, often Twitter's like the one company that's like not really doing much because it's more locked in around this 54.20, just under it.
Well, let's talk about the ways in a merger between signing and closing that would allow either Elon to walk away from Twitter, or in general, provisions that didn't make it into the merger agreement that could have allowed him to walk away. You mentioned a couple up top, but what are the main valves here, the main power tools?
So the main power tools to walk away are effectively one of two types. One of them can be that there is something that happens that was always a little bit of a wild card that, turns out to be such surprise bad news for one side or the other that it essentially allows that side the ability to say, oh man, this is a crazy piece of news. This is so significant that it has and now I'm going to use a term of art, materially adverse effect on my, on my payoff, on what I get out of this contract. And so this contract actually did allow for certain types of material adverse effects to give one side or the other, or in some cases both, the ability to walk away from the contract. But there's a very, very long provision that defines what a material adverse effect is. And it basically has it's almost like a piece of Swiss cheese. It specifies a very general set of things that might be a material adverse effect, which basically have to do with sudden bad news about Twitter's, business, operational, health and so forth. But then it had a laundry list of exceptions, things that you could not point to, notwithstanding the fact that the business and operational condition and financial condition had deteriorated. You couldn't cite to certain types of deterioration if they were the cause of this laundry list of things, these carve-outs. One of them was general market conditions. Couldn't cite to it. It was a carve out. So just because the whole market was tanking and Twitter therefore was probably tanking didn't mean that, in this case, the buyer could walk away. You couldn't walk away in the case of war, right? There was actually a provision that said, regional conflict or war is not a reason to be able to walk away. And as we soon found out, one of the reasons that Mr. Musk played with was trying to argue that the Russian invasion of Ukraine was what gave him the ability to walk away. This provision was so specific, in fact, that it even excluded special things that might have to do with the fact that the personality of Elon Musk was involved in this transaction.
Wow.
And I'll tell you, Joel, I don't know that I've ever seen a material adverse effect definition that actually names a person as one of the carve-outs. I don't think I've ever seen it. I certainly have never been named as one of the carve-outs in an MAE provision. I suspect you have never been either.
Should I be so lucky?
Yeah, he's just a little different, I guess.
The last time I was on speaking with someone about MAEs, material adverse effects, was relating to how COVID had shifted the way some of these were being drafted. I'm sure in this, there was a carve out for the pandemic or other pandemics coming in and changing the business.
Yeah, indeed there was. In fact, one of the areas that I study in M&A is the adoption of these new provisions. And one of the things that we tracked was pandemic provisions. And they picked up very, very quickly at the beginning of 2020. So here we're talking about 2022. They're sort of old hat, very accepted language of COVID provisions. And that was in here as well. So there were a lot of these exclusions or carve-outs that he wasn't going to be able to point to. And I think he knew it. And so, when you're kind of looking over one of these provisions, you're trying to figure out, okay, is there something that's caused the company's prospects to be much worse? That's not caused by the general, declining of the industry. It's not caused by war, plague, pestilence, COVID. That's not caused by the personality of Elon Musk. The list starts to get narrowed. But one of the things that, Mr. Musk sort of got onto is that he sort of reached back to certain of the representations that had been made in the transaction, in the deal, further up in the document. And these were general representations. But one of the representations that Twitter had made is that their previous securities filings with the SEC had been, accurate in all material respects, and did not have inaccuracies that would rise to the level of being one of these MAEs. And so when he started chasing after the bots issue, that was the door that he was trying to execute.
So he was looking at the reps and warranties, and particularly the reps that brought in prior SEC filings and essentially swore by them.
Yeah. And so these reps and warranties, they're often made at the very front end of a contract, of a merger contract. And a lot of them, not all of them, but a lot of them actually reappear at the very end in what's known as a bring down condition that says, look, those representations and warranties have to be true at the time of closing. And if they're not, this person can walk away. And so the thread that he basically the needle he tried to thread was to say there was a representation and warranty about the preceding 10K that Twitter had filed in December 2021 about its overall material accuracy. And then that was one of the representations that was brought down to closing. So if he could point that it was inaccurate and that inaccuracy was a material adverse effect, then he could walk away from the transaction. This has occupied most of the attention in the litigation thus far, and certainly in the public debate about it, about whether the number of bots at Twitter were just extravagantly different than the disclosures that Twitter had made. And that's essentially the route that he was following to try to walk away from the deal. It wasn't a crazy strategy. I mean, buyers will sort of say, hey, if you've got a rep on the accuracy of your financial statements and your disclosures and your 10K, it's fair for us to go back and scour it and see whether you were caught in an audacious and bold lie. But the problem really, and it's always been a problem kind of from day one, is that if you go back to that disclosure, the disclosure isn't about bots as a fraction of all of the users on Twitter. It's a disclosure about only a subset of the users that Twitter thinks has a profile that makes them look like they may be monetizable, like they'll click on ads and things like that. And then of that group, which is a small subset, they then did some kind of manual auditing of samples to see, if we really drill into what these users are, do they appear to be bots or not? And so in their disclosure, they make this description saying, look, we're not claiming anything about overall users, just these monetizable daily average users. And then, we set up kind of a finger in the wind approach to try to figure out, what a representative count would be. We sampled from them. It involves some human judgment. It may not be the best sampling technique. We might be totally wrong about it. Just be advised, everyone who is reading this annual report, we tried, but we might have failed. And so
Wow.
It was clearly lawyered, that statement in the 10K. And whoever that lawyer was, I hope they were one of my former students, because they really did give Twitter a fair amount of bargaining leverage to say, hey, look at this thing. There's very little that's concrete.
This is the disclosure that you're saying was materially false? I mean, look at it. There's not much there.
Yeah, so I think most people who are looking at that particular argument, it was a little befuddling, quite frankly, because it didn't look like a very good argument, yet it was getting pretty much all the airtime, and no one could figure out exactly what was going on with that. My sense is this probably was an infatuation of Mr. Musk. In part, it was an infatuation of his all along, which is another problem for his case, right? If he's saying, hey, I should be allowed to walk away because I was adversely surprised by how many bots there are and what a big problem that Twitter has with bots, you would not figure that if you went back into February and March to try to figure out why he wanted to take over Twitter, that he would also be saying, "Oh, there's a huge bot problem, and I'm gonna solve the bot problem." He more than almost anyone else probably is not going to be surprised by discovering bots. And here, the discovery was really a discovery about this kind of heavily lawyered, mealy-mouthed disclosure.
I wonder if there is an argument that, look, why not actually put it in as a rep or make the company stand behind some number, some threshold on bots, if that really is such a concern?
Yeah. Now, we don't know exactly what was going into the negotiations. There are a lot of depositions. Probably some of them involved the lawyers that were negotiating the deal. But there might have been some evidence that came out in this trial, if the trial ever occurs, of Mr. Musk's lawyers saying, hey, we want you to make a rep on bots. And Twitter's lawyers saying, oh, no, we're not going to do that. You want to, basically take this, take it or leave it offer and buy the company. We're not going to festoon it with a bunch of reps that can later be pointed to as reasons to walk away. So we don't know for sure, but certainly that is not that would not be a surprising conversation for two M&A attorneys to have in trying to negotiate the terms of this deal. And it certainly didn't appear there. So he had to pursue it through this roundabout effort of a general representation about securities disclosures, and then he was stuck picking on the actual definition and disclosure that was just this heavily lawyered thing.
He's using the bots as one, at least predominantly in the public eye, but what else was the argument, I suppose, from Musk and his team?
Yeah, so there were two other arguments to avoid liability, and then if he can't avoid liability, then there might be some other arguments on damages we can talk about later, or on remedy. So one was the I didn't breach, you breached first, right? The sort of like, I'm not, you're not quitting, you're fired type of argument. So Twitter was under some obligations and under this merger agreement. And if they breached their obligations and did so in a way that was a serious and material breach of their obligations, it would then relieve Mr. Musk of any duty to close himself. So one of the arguments that he had made is that they had breached some of their promises on how they were going to act. And he pointed to a couple of different things. One is they suddenly got alligator arms when it came to giving me access to the data that they had to give me access to under under this agreement. That was one. And the second is that they were making a bunch of decisions that under the agreement I was supposed to be consulted on, and I wasn't consulted on, and therefore that breached their covenant to operate the business under its, in the ordinary course, and also get my input. And so some of their decisions, including, this Peter Zatko fellow who gets paid a significant settlement.
Yeah, this was some type of IT executive who was paid a large settlement.
Yeah, this was a IT sort of a cyber security specialist that they had brought in not that long before, probably within the year. And there clearly were some issues, both involving the way that he got along with Twitter's CEO, who was relatively new at the end of 2021 as well as some of the other IT professionals in the office. He had crafted a view, which is probably not surprising for a cybersecurity specialist, that this company has huge cybersecurity problems, right? In fact, I've met now several cybersecurity specialists, and none of them have ever made any other type of claims. And Mr. Zatko, made those claims as well. And we still don't know exactly what went down, but he evidently was shown the door and had threatened to file a lawsuit. It was just before the deal got negotiated and signed that he was shown the door, and they settled the lawsuit during the summer. But it was kind of after Mr. Musk was getting cold feet, and I think they paid him a little under $8 million to settle his claims. And so I guess there's a question about whether Twitter had to consult Mr. Musk to do that and didn't, or whether that was an extraordinary and not ordinary course decision that they made, and therefore they couldn't do it without explicitly contacting him. And that's still an issue, right? I think he hasn't let go of this issue of, Twitter breached this contract first. But those are the sort of the two things, right? The way they're running the company in his consultation, and whether they were sharing enough information for him, at least to suit his needs. It's, again, a kind of one of these things that if you look into the Peter Zatko report and you sort of ask, well, what are the things that he's complaining of? Only some of them touch on things that are in the merger agreement that Mr. Musk could point to. All right. Some of them just point to, oh yeah, I just think the management of this company is bad. Well, that's really on some level a reason for someone else to buy the company, not to run away from the company. And that there wasn't anything like that in the merger agreement. He did talk about bots, but his disclosure in the report that he wrote about bots actually kind of hurt Mr. Musk's case, because he said, yeah, there's a lot of bots on Twitter. It's filled with bots. Now, they do have this monetizable users measure, and that hardly has any bots on it, but there are bots all over the place elsewhere. And if you try to line that up with the Twitter's federal filing, the only thing that they made disclosures about were those monetizable accounts. And so it's almost like that report helped Twitter in that regard and not Mr. Musk. There were a couple of other things that, might have had some effect and might still. One of the representations and warranties in the deal was that Twitter owns its intellectual property associated with this platform. And Mr. Zatko claims that a bunch of what they have is either freeware or commandeered from someone else's IP rights. That hasn't been fully vetted in the public eye. It may never be, but that was one thing that probably some extra ammunition that Zatko brought into the picture. But on some level, Zatko's existence and his settlement might be the biggest issue, as to whether Twitter actually had the authority to do that without consulting Musk, or this was a standard, sort of settlement with a former employee that they were entering into.
That was one other avenue. Is there another that the Musk team was looking at to buttress his claims?
Yeah. There was one other that could have helped them avoid liability, and it has nothing to do with what the contract says. It has to do with an allegation that he was tricked into getting into the contract to begin with. All right. So this is an allegation of fraud, right? That Twitter made various statements to him, representations that may or may not be in the final document, but he never would even enter into that final document had they made the truthful representations to him.
Some kind of fraudulent inducement.
It's called fraudulent inducement. And it is, hundreds of years old, this sort of a claim, that if I can demonstrate that the other side to a contract lied to me in a deliberate, intentional way about something that is material in the contract, I might be able to walk away from it. The two big hangups in that kind of approach, the two big obstacles that you have to deal with, is the first is intent, right? With the material adverse effect, it can be accidentally omitted, but if it's materially adverse, you can walk away. Here, you actually have to show a deliberate attempt to hide information from Mr. Musk. And it's hard to know whether that's there or not, but it's an added thing that a plaintiff has to show. And if they can't show it, they're basically going to lose. And the second is that while you can use fraud doctrine to say that I was tricked into getting into a contract, if the contract that you have basically says, I have been given to my full satisfaction all the information that I need, and so this is sometimes known as a big boy clause, and I therefore am not relying on any pre-contractual representations that have been made to me other than my own diligence on this deal, and I'm a big boy and I can take care of myself, then I don't really get to go down this fraud route. And Mr. Musk had signed one of these big boy clauses. When you think about it, it's not always airtight when you sign one of these clauses, because the argument for fraud is you were tricked into the contract, which may mean you were tricked into signing the big boy clause as well. But it wasn't a good look. Let's put it that way, right? That if you had signed one of these non-reliance terms, which he did as part of the deal, it's going to also narrow his ability to make a fraud claim. So when you add all these things up, the MAE, the Twitter breached first, or I was defrauded into getting into this contract, each of them is a potential, you could shoot for this escape window, but the escape windows just seemed really small, right? If you're a fantastic shot and wind conditions are right, you might be able to make it through.
Why don't we quickly turn to Twitter and look at some of the tools that they had to, I guess, force the merger through. And, maybe before that, are there classic examples of a merger being forced upon a buyer?
There are, and there are several. Probably the most salient one is one that didn't happen very long ago, and it was in Chancellor McCormick's chambers, who's the judge who's actually hearing this case. Much smaller deal. It involved a cake decorating company, and it was a private equity transaction that was in the hundreds of millions of dollars. It wasn't a $44 billion transaction. Buyer got cold feet, however, tried to point to a whole bunch of excuses to walk away, and the chancellor said, "You know what? None of those work for me. I'm going to order this transaction to close." Now, that wasn't the first time it happened, but other than the lower stakes involved, that case, it's called the Decopac case, has a lot of similarities to this, not only on the facts itself, but on the judge. It was her opinion, and it never got overturned. But you can go all the way back over 20 years now. Probably one of the more famous cases is a case called IBP versus Tyson, which is a 2001 case, I think, in which a specific performance order was issued there as well. And courts in Delaware, the Delaware Court of Chancery, it's an equitable court. It has an ability to either say, okay, we're going to have money damages, or we're going to force this contract through. And while the court itself has its own independent discretion to do it, it's also willing to look at the contract and say, hey, have the parties themselves provided for what the remedy was going to be? And that is probably Twitter's strongest weapon in this case.
Why so?
Because there is a provision in this agreement. It's at the very end of the agreement. I think it may be the last provision in this agreement that is titled specific performance. And what that means in legalese is the ability to force the other person to go through with the deal, as opposed to just allowing them to pay damages and walk away from the deal. And so When Twitter filed suit against Mr. Musk, their lawsuit basically was all about specific performance. That's what they wanted from the transaction. In an early hearing, Chancellor McCormick said, gosh, you're obviously going to have to prove, the breach case, but this looks like it's a case where specific performance would probably be available. I'm not making any rulings about that, but it sure looks like it'd be one of these cases where specific performance is available. And this section lays out pretty clearly that except for a few circumstances that may well come into focus over the next couple of weeks, we'll see, Twitter has the ability to ask for specific performance from the judge. And the judges in Delaware, they've kind of made their stock in trade listening to what's in the contract and trying to make good on what's in the contract. So that provision itself, it's a little bit confused because it really gives Twitter the choice between going for specific performance and money damages. The money damages provision is in a different part of the contract. And there, if Twitter went for money damages, they're actually going to be limited. The terms of the contract look like they probably limit Twitter to $1 billion in capped damages if they went for money. There are a couple arguments they might be able to use to get out of that. But if they went down the money damages route, that would be a pretty big obstacle to them. On the other hand, if they went down specific performance, a specific performance order is, hey, dude, you got to pay $54.20 and you own the company and we're done.
And that also would put the company in a better bargaining position, even if they were willing to take damages. It's sort of you better make a number that makes us willing to totally rethink the specific performance.
Yeah, that's exactly right. Anytime I teach my contract students about remedies, and I spend a lot of time on remedies, I say, look, if your case is a case that potentially has a specific performance right, you should go for that. Even if you don't think at the end of the day that's what's going to be enforced, bargaining from the strength of having that specific performance decree is really gonna amp up your bargaining power and is going to allow you to pretty much visit maximal pain on the other side if they want to buy their way out of a specific performance order in kind of a post-trial settlement. And that could happen, right? If Twitter gets a specific performance decree, Trump or Twitter and Mr. Musk might sit down. Gosh, we'll get there.
A good Freudian slip there because of the power that both have wielded on Twitter with their accounts.
Well, it's an interesting thing because the specific performance provision, there's a couple of ways that you could chip at it. All right, one way that you could chip at it is this idea of having specific performance decree as a way to enforce a contract. That is actually kind of the rarity in U.S. contract law. It's an exception. Usually the idea is money damages. And these courts of chancery, and the Delaware's court is pretty much the most famous one, they still reserve some authority to decide whether they want to use a specific performance decree or not. It's what's known as an equitable decision, which means they can bring in a whole bunch of potential policy reasons as well why they're not going to order it. And so one could potentially see Chancellor McCormick say, well, I would usually order specific performance, but here, as we go forward, Donald Trump was a hugely disruptive force in Twitter. Elon Musk says he's going to bring Trump back onto the platform. Maybe society and employees of Twitter are made better off by Elon Musk not owning the company. I'm going to go down the money damages route. I think that's unlikely.
Fascinating. One more area that I suppose could get in the way of a completed transaction would be financing, or if the lenders fell through. Maybe you can explain, is that a concern here? Is that something that's relevant?
It is a concern. Financing is often an explicit condition to closing a deal in the private equity space. And so a lot of these take private transactions will have a specific condition at the end that says if financing fails, the buyer gets to walk away. This one doesn't.
Oh, wow.
It does enter into remedy, however. So if you go back to the specific performance paragraph, one of the potential limitations on it that I noted earlier, elliptically, was that that specific performance remains kind of contractually an option for Twitter unless financing has failed. That's one of the key conditions that could force them off of specific performance and onto money damages, which, remember, are probably capped at $1 billion. You end up in this situation where Musk, having recruited a bunch of these lenders and investment bankers, possibly bullied them onto this deal in a sight unseen way, is now, kind of hoping against hope that they'll pull the plug on the deal. Now, here's the problem, is that there are some cases that have had a similar structure. And in fact, that cake decorating case also had this structure to it. And the buyer in that situation actually kind of hustled his lenders to pull the plug. He basically sort of, exhorted them to abandon the deal. They abandoned the deal, and then he came in front of the court and said, "Oh gosh, I'd love to follow through, but my lenders have evaporated, and it appears that having no finance anymore, the plaintiff's going to be stuck with money damages." And Chancellor McCormick in that case said, "I'm not buying it. If the reason that your lenders disappeared is because of actions that you took as the buyer, and you could have prevented them disappearing, then I'm going to basically treat it as though they haven't disappeared. And I'm going to order the closing of this deal. And it really sucks to be you, dude, that your lenders have disappeared, because you're going to have to go out and find more lenders." And so financing disappearing, it's always been this odd and precarious dance, because if Elon Musk's fingerprints or even his DNA are on a decision to pull financing, I think the same prevention doctrine argument holds sway. And so the lenders are going to have to argue that they get to walk away for totally independent reasons. Now, that in turn is going to be subject to a different contract, to the contract between the lenders and Mr. Musk. What are the conditions under which they can walk away? And it's pretty good practice, and they did it in this case as well, is that they basically specifically tied the lender's ability to walk away from the deal to Mr. Musk's ability to walk away from the deal in the main contract. So only if Mr. Musk has a valid case to walk away himself would the lenders have a valid case to walk away from financing, and vice versa.
One other thing that came out in the litigation were some of his text messages. How was that brought in, and why was it public?
Well, so part of the issue that involves how this case is going to go forward is really going to be to what extent does a sudden financing failure reflect the fact that the financiers, they've always been grumpy about this deal, and now they want to take off from the transaction. And a lot of those backs and forth between both the lenders and the equity investors sort of suggest that people were chirpily deciding just to throw in with Elon Musk, that this didn't seem to be the biggest consideration for them at the time. I think also, given that so much of his claims about the bots being this sudden, surprise, really made it important for Twitter to be able to say, okay, well, what do we know about what you were telling other people at the time that you were trying to recruit them onto your investment team, either as equity holders or lenders? Were you basically saying, yeah, don't worry, there's no bots problem? Or were you actually saying, yeah, there's a huge bots problem, but I alone can fix it?
I'm going to solve it.
Yeah.
Yeah. That's fascinating. And you mentioned earlier something about bullying the investors. I was reading some of the tweets where it seemed like, hey, buddy, you want to chip in on this? Sure. What do you think's the right number? I don't know, $1 billion?
Yeah.
End of conversation.
I just I want friends like that, first of all, who would just be willing to front me $1 billion on a text message. And so, it looks like, these are some of the serious big players in either, Silicon Valley or sort of crypto finance, sort of the Larry Ellison, Sam Bankman-Fried type people who were kicking in a bunch of money. It seems pretty clear that that was kind of it was the boys club financing model that he was going with, particularly for the equity financing. So it seemed like he wanted kind of high profile names. He was getting a lot of high profile names. They were not asking a lot of questions. Indeed, the agreement seems to be 2 or 3 lines of a set of text messages, and that was the commitment.
What you were talking about was more related to the financing, the debt financing that would be more relevant.
Yeah, I think that would be a little bit more relevant. And the fact of the matter is the debt financiers, suppose they came in and they had done a big projection, a net revenues projection or a valuation projection. Man, Twitter would want to see it. Like, how are you using, what reasoning are you using to justify going forward with this deal? And so since so many of Mr. Musk's own defenses seemed to hinge on him being unfairly surprised, it became fair game to say, well, we gotta see what you were and weren't surprised about. We need evidence about conversations that weren't privileged conversations that you were having while you were getting into this transaction.
I don't think we'll ever know for sure why Elon backed away from his attempt to escape the deal, why he came back to the original offer. But your best guess, it's a combination of sort of a difficult legal claim in the first place, some financial risk, and maybe embarrassment or exposure of him, bad PR that just wouldn't make it worthwhile.
Well, yeah, I think that last one and sometimes it's easy to belittle that, but if you think about it, here's a guy who is able to pull in billions of dollars with sort of, hey, bro, text type messages. There aren't too many of us who could do that. I'm going to just say here to your great surprise that I'm not one of them. And so, basically these folks that are willing to, to write a 9-digit check to you, a 10-digit check to you, they're doing it because they kind of trust in the bond of your friendship with them. And if that gets sort of dragged in front of a public proceeding, that can certainly do some damage to that reputational capital. So it may also have been the case that, Mr. Musk was not only not that excited about himself being personally embarrassed, but, possibly that
he didn't want to embarrass his friends.
Yeah. Imagine you're defending yourself. Oh, no, that wasn't me. That was crazy Larry Ellison who said that, and he's nuts. Everyone knows he's nuts. Well, that then becomes something that's on the video, right? And I'm not saying that Ellison is nuts, but that you can get into a deposition where you're kind of backed against the corner and you start thinking about ways out, and maybe that involves throwing some of your friends under the bus, and then it's a videotape deposition, and that comes out later on. And so I think that there was always going to be a little bit of unpleasantness around that, and that might be another reason to say, hey, I'm not going to go through this deposition. I'm willing to pay money, and in fact, I'm willing to just close the deal on its original terms, which he eventually announced that he was going to do, subject to some conditions.
And Professor, one last question. We've been talking about the Delaware Court of Chancery, Delaware law. Is there anything that we should be thinking of that's not Delaware that's of legal concern in this matter?
I think that the odds are pretty low that anything outside of Delaware are going to come and upend what's happening in Delaware. There are maybe a couple of kind of serious wild cards, so I don't want to overplay their importance. One is, to the extent that Mr. Musk was complaining about disclosures made in federal securities filings, he's a shareholder of Twitter. He, in principle, could say, there's been federal securities fraud going on here, and I want to sue to enjoin any transaction, any vote that was procured as a matter of federal securities fraud law. He hasn't tried to do it. He couldn't do it in a Delaware state court, but might try to do that in a Delaware federal court. I think the time for that has largely passed. I don't think a Delaware federal court's going to try to butt in on Chancellor McCormick's processes. The second one, which is I think also kind of an equal wild card, is, but it's conceivable, is that the U.S. government has a role to play to approve, or in some cases veto, and in some cases reverse mergers that the government views to be adverse to the national security interests of the United States. And during the first couple of weeks of October, Mr. Musk tweeted out some messages that seemed almost like he was reading a script that was provided for him by Vladimir Putin about how to end the Ukrainian crisis. That seemed to be, a lot of the talking points of the Russians.
There was some call to compromise and letting Russia keep what was formerly sovereign Ukrainian land.
Right. And kind of a little over the top saying this has been Russia since 1750 and so forth. And there's, at least the most conspiratorial of theories might say, hey, maybe he's doing this to try to goad federal authorities into getting so nervous about this transaction that he's going to be sort of a hand puppet to Vladimir Putin after this deal closes.
Wow.
Trump comes back on. Putin is now given access to all the user information of what's going on Twitter, that there are serious national security issues here. Now, during the Trump administration, a Chinese purchase of the gay dating app Grindr got reversed under the theory of national security interests. Usually these kind of cases deal with, companies that like make drones or aircraft, not social media companies, but its application was expanded a bit. And so it's something called CFIUS. It's the Council for Foreign Investment in the United States, and it's all at the administration level. And so it's essentially under the president. And if the president makes a determination that there's a national security issue here and I want to put the kibosh on a deal, it's not even reviewable in a court. The substantive decision is the president's and the president's alone. And so, I guess there's kind of this weird outside possibility. I think it's pretty remote that there's some backroom brokered political deal where Mr. Musk, says, okay, look, if you will foreclose my buying Twitter because you think I'm, a Russian agent or something, I will, I'll back off of trying to pull away Starlink access to the Ukrainian troops, and I'll play nice with all my SpaceX assets and so forth. The fact of the matter is, the government doesn't have to put the stop to this deal now. They can wait till it closes. They can wait till all the shareholders of Twitter are paid off, and then march in and say, yeah, Mr. Musk, we don't want you owning this company. You have to now sell it back out to whoever the highest bidder is. And then he's going to have to sell it under then prevailing market conditions. So the fact that the government doesn't even have to move now, they can move later, gives them a lot of bargaining power. So I don't think it's going to happen.
And probably undercuts that strategy, because then he shoot himself in the foot again.
It's another high risk strategy, much like chasing the debt away. But if you're in the if you've gone down deep into the rabbit hole of trying to handicap all the different possible warrens inside the rabbit hole, this is a fairly obscure warren that's way back in the back recesses of it.
Professor Talley teaches at Columbia Law School. Eric, this has been so much fun. I really appreciate the time.
It was great. It was great to be here.